the many Superior Court judges who labored over the underlying dispute and who now continue to do so in the criminal division. Yeah, what's up?
I apologize for cutting you off, but what in the hell are we reading? Like, what is this?
Oh, so this is in the Arizona Supreme Court. You know, she had filed with the Supreme Court, and so this is his. I guess I don't know if it's like a.
Is this the response to Jingris's thing?
This is Clayton's response.
Okay.
Right.
All right. I'm good now.
This is actually just one of my diary entries, man.
This is what they look like. They're all in 12-point fonts, Times New Roman.
Absolutely.
Legal jargon.
I dictate them now, so.
I dictate.
I'm not a fan of the EM dashes, but I am glad that they brought up the criminal charges in the first sentence.
Yeah, right.
Pro move.
It also does not diminish the diligent interest of public observers who have followed, scrutinized, and reported on the proceedings with voracious appetites for transparency and understanding of the legal process. None of these acknowledgments change the simple fact that Laura's appeal failed to develop any meaningful issue that this court could properly consider. A case can have substantial meaning to the parties and even the public while having nothing to offer in developing the state's common law. The Court of Appeals found that Laura's arguments, the same she asserts in the petition for review, were not just incorrect, but were unreasonable, not grounded in law or fact. Sorry, that gets me.
They're quoting, did you read that, or did you just remember it to quote it?
Right here.
Oh, so they're quoting the judicial appellate thing.
Yeah. Did not meaningfully address the trial court's rulings and ignored the applicable jurisprudence. On appeal, Laura did not meaningfully challenge the trial court's substantive findings. Instead, she suggested that this paternity action somehow transformed into some other type of proceeding and ignored that the trial court was required to sanction Owens for the costs and reasonable attorney's fees Echard had incurred, caused by her misconduct.
Can I make an observation?
Go for it.
Bruce's avatar. Is Bruce's avatar picture like the equivalent of guys doing duck lips?
No. Guys doing duck lips is guys.
Because he's doing like this. He's
like,
lips. I can't do the face, but he's doing the face.
You do the face. You need to do the face now.
I can't even do that. I don't know what he's doing.
When I was out at lunch, man.
I could kind of do.
Here's the thing. Here's what I
said. No.
I think.
What's going on under the glasses? That's important. Are you have bug eyes, or are you like looking like?
No, I'm smiling. It's a good day. It was Friday. I went out for
You're
lunch.
Not smiling.
It was a good day.
Oh, I'm just busting Bruce's balls. It's Friday, man. It's Friday.
That's as smiling as
I'm starting to get a little squirrely. I'm not paying attention to whatever you're reading, Lauren. I feel like I've already addressed this.
I am, Lauren.
As much as I'm going to with Rachel Juarez.
No, we've traded places. Like, I cannot pay attention when we're doing it for you, and you cannot pay attention when we're doing it for me. So yeah, no, you and Rachel are definitely more interesting sharing because we're just like all over the place. It's bad. I've accepted that. Okay. But
fair enough.
Lauren,
we're here anyways. What?
Lauren.
What?
So I feel like if they make a documentary, they can call the documentary whatever they want, like all the best, whatever they want to call it. But I think the subtitle should be not grounded in law or fact. That would be an amazing documentary subtitle.
Man, you broke up a lot, but I heard not grounded in law or fact would be a great subtitle. So I agree with that. Yeah.
If for like a documentary subtitle.
Yeah, true. I mean, I haven't heard too much about that lately, but hopefully they'll, move forward with that. So.
Oh, there's things.
Man, I know, I can't say that. Where were we before Omar interrupted me? Because.
Whether or not that is the equivalent
on that
of duck lips for a guy. Oh, we're on something more important. You're right. Bruce is right. What were you talking? What were you on about, Lauren?
Why did
I failed to identify with any particular?
This is like when I was at your desk. It's terrible.
You were literally army crawling on my floor.
Hey, it was one time. My God. Okay.
I was trying to be serious, and then you were you were on one.
I wasn't on anything, bro. What are you talking about? I was just sitting. It's the middle of the day. What are you on?
Oh my God. It was like 4 p.m, as I recall it.
It was like 4:30.
It's almost 4:30, Lauren. We gotta go.
I know. Yeah. Hey, man. Oh, we're starting flat like at 5:30 for inquiring.
All right, whatever.
I'm pushing it back. It's been a long day.
Well, you probably need to get your shit together, obviously. All right.
No, I do.
She failed to identify with any particularity what evidence supports her argument and applied incorrect legal standards. The Court of Appeals found that her unsupported and speculative allegations against the trial judge failed to meet her burden to prove bias, and that she did not challenge any of the presiding judge's rulings, denying the motion for change of judge for cause. under the appropriate standards for appellate review. The underlying appeal wholly failed to raise meritorious claims. There are no issues for this court to properly consider because they were either not implicated in the trial court's ruling or not meaningfully developed on appeal. Of the hundreds of cases vying for limited space on this court's calendar at any given time, this one simply does not rank among those with important questions of law, deserving the state's highest level of jurisprudence.
That's basically saying we're responding for the sake of responding, but there's nothing to see here.
Okay. Yeah. I don't know what it is with you guys in the chair, okay? But people liked when I sat in the chair for some reason. I don't know.
Oh, well, I had to adjust the camera angle for you. For one, I remember that. I had to point it all the way down. Because
because like if you don't do that, it's like Chin City, man. I don't want that.
Oh, boy.
It's ridiculous.
Yeah, you got to be pointing down at yourself for a good Instagram selfie. I learned that in Dave Neal chat.
Yeah.
You have to point. Wait, is that the move? I've been doing it wrong the whole time.
Yeah. I
Yeah,
guess
the camera's got to be above you.
Yeah.
That's my angle, just like full on. That's what I feel like. How is that better than just straight
No, that
on,
looks
though?
like a mugshot. No.
I don't have one of those yet, but the FBI did call about my marijuana use today. So
you know what? We should do AI mugshots and use that for the thumbnail.
Oh, that would be good. When there's a guilty verdict in the Arizona v. Owens case, we'll all do mugshots.
So prospective titles for the Laura Owens documentary from ChatGPT.
Shut up. Sorry, not you.
Really? I think all the best is the only thing you can do.
No, I don't want ChatGPT.
I mean,
that's
pretty good.
That's cheap shit. No, come up with it yourself.
No.
Same with the mugshot. I'll put cuffs on. You're not AIing me. I'm not doing that.
Did I show you my Father's Day AI picture with me and my brothers?
No.
I'll send it to you later.
Okay.
It was pretty good.
Not too much later though, because
I'm tired of
waking up
done
with
legaling for the day.
I like wake up in the middle of the night to Omar staring at me on my phone. I'm like, oh, Jesus Christ! I can't tell if this is supposed to be sexy or scary. Like, what is this?
When did I do that?
No, when you sent me that weird picture of you with like angry mugging at the camera in the gym
that
or
was
something.
like my advertisement for the
swimming match. Is this supposed to be a proposition, or are you trying to scare me? Like, what is happening here?
Oh,
it almost worked.
Laura Owens is here.
Yeah.
We love fake Laura Owens.
Oh boy. Guilty verdict as if. Oh,
right. Fake Laura Owens is going to fight this thing all the way to the whatever. All the way
I actually don't think
prison.
she's going to. I feel like she's going to plead. I think she's got a good criminal defense attorney.
I'm not going there.
Yeah,
I refuse. That's
Omar,
not happening.
So here's the thing.
When?
Do you take a plea deal like 24 hours before court? Like when do you play chicken? Like when do you dodge?
They got these pretrial hearings. In California, this is how it goes. There's usually 3 or 4 of those where there's offers exchanged. Sometimes there's extraneous discovery, additional. They'll make an initial offer. It's like, okay, I'll see you that offer, but look, this is what I'm thinking. Give her this.
Those are already set on the calendar.
Yeah, so they'll be negotiating. So the pretrial, that's literally what that's for. All the in-between communications.
First is July 11th.
So July 11th. Honestly, if this was like a normal trial, they could probably wrap this up by the end of the year. In a few months. If it was a normal trial. However, I can also see a world. I think they're negotiating
another
right now.
6 months?
Mm-hmm. Well, I don't know about 6 months. It's up to the DA and how far they want to carry that. But they got to get to a point where they're finished with the pre-trials and we're just setting trial dates. We're not close to that yet. It'll be a few months.
She could have like 6 fake pregnancies in that timeline, guys. I don't like it.
But she's changed course. Like she's not on social media anymore, as far as I know.
I give it 1 month. I give it 1 month.
Well, we'll see. So long as so far, the new defense attorney is doing everything I imagine he should be doing.
Yeah, I don't know if he's some kind of wizard or what, because she's never shut up before. So.
Well, sometimes the threat of going to jail is pretty powerful.
I don't know. It didn't seem that powerful when she was threatening the county attorney in her fucking
that's
blog.
because David Gingras was her attorney at the time, and he was encouraging her. How about
don't you know that he's never been her criminal attorney, and also a lot of stuff that happened here is before his time?
Oh, I'm sorry. He was her representative.
I thought they were just
agent in training, PR specialist. David Gingerbread Gingras.
That's a great advertisement.
As much as I would like to see a trial, I agree with Omar.
I don't know. I don't think
If
she's
this
gonna,
gets to trial, something went wrong. That's what I'm telling you.
I feel very confident that something's gonna go wrong. That's just me. I don't know. She's never steered me wrong before in my judgments of her.
Oh, yes, she
stupid.
has.
So no, she has not.
Oh, no,
every
the
single
opposite of
time.
that. You're
Every
right. I
single
didn't know where
time
you're
she
going with
does
that.
the crazy thing. She always does the crazy thing.
That is
Oh,
true.
wait.
Even when we tried,
Also,
wasn't there a
Omar.
time? Yeah.
Lauren, who's
No.
that guy in San Francisco, the wacky guy from the news guy that we looked at on YouTube?
Rich? Are we talking about Rich?
Oh,
Rich.
the
His video
Ron's
stayed up.
friend?
You owe us Taco Bell. His video stayed up more than 48 hours.
God.
Was
I
it
have to
Taco
feed-
Bell
I
or
have-
something?
how
I
many
thought it
people
was
Yeah,
like
I got him
a
a $7 buck box.
So, see, how many
karaoke
people do I agree to
song.
this for? So like
She was going to
where there's
sing
like three
"I'm
of you?
Every Woman."
I don't.
No,
I don't know
want
if that's
karaoke. I want Taco Bell.
okay. Well, you guys get one or the other. You're gonna have to work it out amongst yourselves.
Maybe a
Yeah.
hybrid of sorts.
Taco Bell.
I'm not
Taco
singing
Bell
at the
while you're
Taco Bell,
humming.
bro. If I'm doing that, I'm doing it on the toilet. It's not happening. Okay.
Oh boy,
Oh boy.
Yeah.
I pass.
That's what I thought. I know how to get out of things, don't I? All right.
Jesus.
Where were we on this? Before you were such
Oh, the record does not present a Rule 26 safe harbor issue that this
Yeah,
court
okay.
could consider on review.
Oh no, keep going.
Oh, well, shit. All right.
Shit is right if you choose Taco Bell. No, go ahead.
The petition for review reproduces a relatively succinct summary of Laura's Rule 26 argument and does not differ in any meaningful respect from what she proffered in the lower courts, relying mostly on case law interpreting Federal Civil Rule 11. Laura argues that every litigant is entitled to an absolute safe harbor from sanctions in the form of written notice and an unconditional opportunity to dismiss the litigation. The only significant addition in the petition for review is the history of the family law rule amendment and renumbering from Rule 31 to Rule 26 in the 2019 restyling. Petition at 1011. This history is irrelevant because the trial court did not sanction Laura under Rule 26 or abrogated Rule 31 or Civil Rule 11 for that matter. The petition acknowledges that the Court of Appeals refused to even discuss any of the federal authority supporting Laura's position. But she still seems to misunderstand the reason her argument failed. Rule 26 was never the basis for the trial court's judgment and had no effect on its ability to award fees. The trial court awarded fees and costs under ARS Rule 25 and ARS 25415. Even if Laura's interpretation of Rule 26 was correct, a thoroughly contested hypothetical, it was irrelevant to the trial court's analysis. The court was neither required nor persuaded to grant Laura's motion to dismiss her petition after Clayton filed his response and made substantive counterclaims. By rule, once a response is filed, the court may dismiss a family law case only on such terms and conditions as the court deems proper, including the resolution of any claims by the responding party. Rule 46A1B, Arizona Rules of Family Court, subsection 1. But what am I reading that? Laura's original motion to dismiss even acknowledged this barrier, yet she failed to challenge the denial of that motion on appeal. The Court of Appeals disposed of this entire Rule 26 argument in 3 sentences. As a preliminary matter, we note that a significant portion of Owens' appellate argument relies on her incorrect assertion that the trial court ordered sanctions under Rule 26. The court expressly awarded attorney fees and costs under ARS 25. We thus decline to consider whether an award under Rule 26 would have been proper. Despite vehement disagreement on the merits of this argument, the topic of whether and how Rule 26 should be interpreted is not before this court. It was not properly before the lower courts either. Given its limited and discretionary calendar, the Supreme Court does not grant review to weigh in on hypotheticals or resolve purely academic debates like this one. In other words, this whole exercise is stupid. I'm going home. All right.
This is
I don't know, man.
amazing. Yeah.
I saw a YouTube video about it, and I think you're wrong. So,
Well,
my God.
This is so crazy because from the moment they withdrew the Rule 26 sanctions motion and responded to the motion to withdraw and everything. They had explained this the way they're explaining it here. We're over, what, a year or 2 years into this, and we're just explaining the same thing over and over again to different judges.
Yeah. Well, it's like
it seems insane.
It's like what Rachel said. She said that the fact that they awarded attorney fees in this appellate review was a resounding FU to David Gingras and Laura Owens. Like, this is a waste of time.
Yeah.
You shouldn't pursue this any further, and yet here we are. And so,
do you think he's actually going to try to bring that to the Supreme Court?
Do it. Do it, bitch. I think at this point,
you have to encourage that. I mean, come on, bro. You know he will. But I just wanted you to tell me what I wanted to hear, which was no.
Oh, well, I've been saying that, I feel like, for a whole year. But what do I know? I'm not even an Arizona licensed attorney.
You've never been in federal court, bro.
I know.
I heard that about 40 times. I would never have known if he hadn't said that. So it doesn't matter to me.
Just check Pacer. Oh, by the way,
I don't need to be checking Pacer any more than I have checked it because my bills are disgusting.
I need to GoFundMe to raise the $80 to get my federal license.
I could do that.
That's literally all I got to do.
You don't need to GoFundMe for that, bro. But we could do that.
You mean that thing
just to be petty.
GSG threw shade at you for?
Oh yeah. Hey,
how
Lauren,
ridiculous.
did you how much money have you raised for your Pornhub premium subscription?
Fuck you, man. I have like $250 in my account. And
That's
I went
a lot
through
of porn.
a lot of them were like, get the premium. I was like, no! But then some of it was just Pacer bucks. So I was like, all right, cool. So I would say it's about half and half. So maybe like $120 is like somebody trying to get me to buy porn because you started that.
So what did you buy?
Nothing. It's just sitting there. I haven't decided what to do with it yet. I guess pay my Pacer bill. I mean, I don't know what else to do with that.
You know, that's actually good use of that money, the Pacer bill.
Yeah, I'm gonna need it.
Because he told me how much the bill was. I was like, Jesus Christ, Lauren.
Oh, it's bad. I mean, it's bad. How bad would you say that is in relative to like normal?
Well,
people?
could I just compare? Mine was like $100.
All right, so we're about all right. I'll tell you right now, what I have for this quarter is already 10 times that. So I'm not gonna say any more than that. But yeah, that's okay. I make way more than enough to make up for it. So
all right, I'm just saying, there's cheaper ways to go about it.
Yeah, but those are like slower and less intense ways, and I don't do that. So
that's true. You're Johnny on the spot with every little thing that happens
all the time.
That's why you're so rapidly ascending.
I have one speed. It's
hey, so what are you doing tomorrow anyway? Aren't you going to be like on stage somewhere?
Tomorrow, dude, that's next month. What are you talking about?
Oh shit, I don't know. I'm just
no, it's the 13th.
For whatever reason, when you text me, I thought you meant tomorrow. You're going on stage with Zach Peter and.
Look, you bored Bruce to death. He left us. No, I'll be at Zach's show. I'll be on with Zach and Andy on the 13th, July 13th.
And Podcorn Productions.
Yeah, that's Andy from Popcorn Planet. Yeah,
that'll be cool.
Mm-hmm. Yeah.
If I can make it down there, I totally will.
Okay. Yeah, you should. Well, because Laura's got that hearing on the 11th. So
well, I ain't going for Laura. I mean, literally, it's going to take.
No, I know you would only follow me everywhere, right? But I will go to that because I'm going to be there anyways. So.
I don't know. It might be hot. Also, it might be working.
I'm still going to be there, so it doesn't really matter if it's hot. Yeah.
Fair enough.
All right. Well, I think we lost Bruce, but we're almost done with this. Hang on.
You have some Pornhub questions I think you should get to.
I really hate you for that. I mean, I don't hate you that much because money is money, but all right. You should read this. This is for you.
Wacky next move, becoming a nun, moving into Vatican, no extradition. Bonus, lots of single guys equals more twins. Oh, could you imagine? Laura Owens as a nun?
Do you think those guys in the Vatican want twins?
They would call it the immaculate duplication. How about that? I thought that was pretty good. I think it deserves a laugh. Fuck you guys.
That's good.
Sorry, I already saw that title on Pornhub Premium, and I'm good. So, all right. No, you know what? You have to read this because when you read, you don't do this. Okay, when you read, you're just reading. So please read the page for me so that
Yes,
your ADD doesn't take over the rest of.
I'm sorry. It's Friday, man. It's Flat Day.
You don't have to
And-
explain it to me because I'm exactly like that most of the time. But right now,
Okay.
I need you to read the page.
Okay. Excuse me. Laura argues that the Court of Appeals erred in refusing to apply a structural error standard in the trial court's erroneous finding that a witness testified that Planned Parenthood is not open on Sundays. When Laura testified, she sought care July 2nd, 2023. The day of the alleged visit is only noteworthy because Laura's testimony at trial substantially changed from what she said at her deposition and in subsequent sworn affidavits. This was not a key adverse finding and served as nothing more than cumulative impeachment. Laura has presented this argument in various ways throughout the proceedings, arguing that the inclusion of this statement proves the trial judge conducted an independent and undisclosed investigation into the facts of this case. I think you got to give Gingras a little bit of some kind of points for creativity.
Well, they would be, if he got points, they would be brown. Absolutely.
They would be brown.
Keep reading.
The finding proves the trial judge was biased against her, that she was denied due process, and that the undisclosed investigation she speculates occurred constitutes structural error. Laura frames the issue as one of obligatory judicial recusal and further contends that refusal to recuse is structural error. Neither is an accurate statement of Arizona law. In all judicial proceedings in Arizona, no cause shall be reversed for technical error in pleadings or proceedings when upon the whole case it shall appear that substantial justice has been done. The rules of family court procedure espouse the same harmless error standard. It is well established in Arizona that a due process error, if what Laura describes even constitutes one, requires reversal only if a party is thereby prejudiced. When a party challenges a judge's impartiality, including alleging extrinsic information as evidence of bias, recusal is not required without showing prejudice. Prejudice will not be presumed, but must be evidenced from the record. Laura's most recent iteration of this argument conflates an ordinary allegation of judicial bias with the extraordinary form of bias necessary to trigger structural error review. She must
Omar, can you give an example of structural error that would require recusal?
Yes.
Does it involve anybody's dad?
Failure to take a knowing and intelligent plea without all of the proper precautions would render that a structural error insofar as that you cannot make a finding of a knowing and intelligent plea. So whatever plea was proffered would be stricken, and they'd have to start all over. Like, for example, in immigration law, if somebody is found to not speak English and they give the plea language in the English language, and they give all of the warnings and admonitions in English without a translator present, then the sentence that stemmed from the plea would be stricken because of structural error.
Structural error.
A due process violation. Meaning we can't proceed because this bad thing happened. That's one example. Okay. Where did I leave off?
Oh no, you lost me now.
I felt like I was on Ask Two Lawyers for a minute when they were like quizzing me about stuff. It did not.
That's why I'm here.
First, the Court of Appeals reject. No, but that's a good question. Because Gingras kept on raising that issue over. Well, first, the Court of Appeals rejected Laura's argument to apply structural error analysis because structural error did not occur. Thus, even assuming without deciding that structural error applies in family law cases, it did not occur. And the presiding judge did not abuse her discretion in denying Owens' motion for change of judge for cause. In other words, what Gingras was trying to state was...
I'm sorry, I can't stop thinking about Look at Me Daddy.
Judge Laura was so biased, she was so compromised by potentially conducting an independent Google search of Planned Parenthood hours that it rendered whatever happened at the June 10th trial as moot in violation of a structural error should have been thrown out. That's what he was basically trying to say. All right, Lauren. Now Lauren's doing
Hey,
it.
Omar.
Yeah.
I don't know if my
can't
internet's
help it,
working.
man.
Okay. Let me ask you another question.
Sure.
Let's say that this Planned Parenthood on June, whatever it was, July 2nd.
I'll be right.
Let's say this Planned Parenthood closed on Sunday
Yeah.
was actually important to the case. I say it's not because no Planned Parenthood ever sent Greg Woodnick a verified ultrasound. But let's say it was important to know whether Planned Parenthood was closed or not. What do you think would have happened here?
Well, it was important. Insofar, well, I don't know. Did she use
I understand it's
schedule
important in sort of proving perjury, but in terms of the paternity case.
Yeah, so if it was that important to the paternity case, like if they knew that Laura Owens was going to lie about her date, I feel like it would have been submitted in the
Which time?
pleadings
Sorry, which time?
and admitted the proper way under the evidence code, and it would have just been made a part of the record because we would have had to know, like, fundamentally what is the Planned Parenthood schedule. But because it happened the way that it did, nobody knew Laura Owens was going to lie on the stand. So she opened the door to making it relevant because it was now impeachment, striking her credibility.
Okay, but the what would that do in terms of the judge writing about it in the ruling?
Yeah, it just goes to her. I think Judge Mata took that as not necessarily important to the merits of the case, but it spoke to the credibility of Laura Owens.
Okay.
In conjunction with all of the other stuff, and it was why she gave the ruling that she did.
I see. It's just, it's all a matter of credibility.
Yes. I'm getting
after
distracted
just having
by
these
Lauren.
5. I don't know what is wrong with Lauren, but
I did not give her a gummy.
I know.
She's all on her own.
No, I haven't even taken one yet. I'm gonna stop the camera
Petting
again.
zoo. What the heck?
Oh.
That's just really not what I'm into.
Oh boy.
What
I need
about
a
the
break.
two-way petting zoo?
Stop
You
talking
pet
to
the
me.
animals, they pet you back?
All right, you killed the mood. Thanks.
Yeah, the other thing, Omar, when I went back to the
Fucking dick.
boy, god dang it. When I went back to the February status conference and those related filings, they were Woodnick was constantly talking about disclosure and discovery violations.
Yeah.
And I think it really goes to that more than anything else.
The Planned Parenthood issue?
Yes.
Not necessarily. There was a
they were there on June 10th. Oh boy.
You right, Bruce?
Whoa.
No, I think they were there on June 10th.
Hmm.
And we were learning new things or discovering things when we didn't even have complete discovery in February.
Sure.
Do you know what I mean? Like, there's a whole problem here.
I don't remember what the main discovery violations were. It's been a while, but wasn't that
But it
about,
was just
like,
the lack of turning over any materials. So if you go back and watch the February hearing, Corey Keith's like, oh, sure, my client can provide all this evidence. And we haven't sent it to Mr. Woodnick yet, but we will.
It's in the Dropbox.
And then, of course, they never sent anything useful.
Was it ever addressed in like a motion in limine, pretrial motion? The things that they request in the discovery, since they haven't been turned over, cannot be used to argue your case?
I think the only thing they ever did that with was Mike, right? It had something to do with
No,
Mike.
they never limited the discovery. The only thing they said was, don't publicly disclose healthcare information for the other side.
Oh, right. Okay. I remember what you're talking about now.
All right.
Poor Corey.
Anyway, I think that gets to the heart of this Planned Parenthood closed on Sunday thing.
No, because if they wanted not just in terms of the schedule, like if they wanted the schedule, they would have just subpoenaed the official business record from Planned Parenthood. But they never needed to do that because it wasn't going to be dispositive of the case. The only reason it became relevant that we're still talking about it is because Owens got on the stand and lied.
Exactly. And there's a track record of not providing adequate disclosure in this case that goes back before June 10th all the way to February and before. That's my point.
And that's why she's now facing federal felony charges.
Yeah.
Because of a lot of that stuff, and maybe some stuff that we don't know. And may never know because it might not go to trial.
Omar, I almost wish the judge had written Judge Mata had written her ruling in sort of two sections. One section about the paternity case and the fees, and one section about the referral to the county prosecutor.
Yeah. It was kind of all lumped together. Like the referral was like the last paragraph after the fees.
Right.
Yeah.
I wish they had sort of divided it up a little more clearly. I think that would have been better for us as readers.
I mean, I thought it was pretty well segmented. But maybe you're right. Maybe 3 separate pages dealing with those 3 issues individually may have been more clear. It always helps. But
I mean, that's in hindsight. You always 2020 vision.
Yeah. Hey, Lauren, do you want to read?
No, because you'll interrupt me every other sentence, and then you'll go off on a tangent about Bruce's glasses and his duck face, and we're just going to go around in circles. So why don't you read the rest of the pages, mister?
Are we almost done? How many more pages is this?
As many as you have to finish right here. I don't know, 2 more pages?
Okay, I could.
Does it matter? I'm going to make you read all of it.
Yes, because I got a dip like in 5 minutes.
You'll be fine.
I'm going to prep for Vlad. Okay, are we on the structural error thing?
Prep for Vlad. Okay. All right, go ahead. You mean you got to get drunk?
I also have to go.
You have to tell me.
Oh, I bet. Hey, Bruce, is it gaming night?
It is, I think.
It is gaming night, yeah.
Oh. Hey, are you playing this game, Baldur's Gate? Do you know
I
about
have
that
played
game?
that, yeah. Yes, I do.
Is it any good?
Send me your questions.
Well, I just don't get it.
Email.
I'll send you one later.
Send me your questions in email.
Okay.
Nobody wants to play Fortnite? Okay.
That's for, you know what? Let me just read.
Don't even say what you were about to say. Read the
The Court of Appeals found.
I will fight you.
Jesus. The Court of Appeals found that a biased trial judge may be considered a structural error. But Laura failed to show bias. Both the presiding judge and the Court of Appeals found that Laura's unsupported and speculative allegations failed to meet her burden to prove bias and rejected her claims on the merits. Scroll down, Lauren. Whoosh. There you go. Moreover, Laura failed to show the type of bias necessary to implicate due process rights, although landmark criminal cases like Ring and Valverde generically refer to judicial bias as structural error. The defendant must allege a form of bias that would implicate his due process rights, such as that which is based on a direct personal substantial pecuniary interest to establish structural error. Is this enjoyable? Listen to me read this very technical.
Just read it. We're almost done.
Just accordingly, even if the structural error doctrine could theoretically apply
in
criminal proceedings,
just read the page.
The facts necessary to establish such an extraordinary defect in the trial mechanism simply do not appear in this record. This is another abstract question that may appear academically interesting, but its answer will have no impact on the outcome of the case. In sum, oh, Jesus Christ, what is this? The Court of Appeals also analyzed Laura's argument as a claim of judicial bias separate and apart from any structural error or presumed prejudice claim. A judicial bias claim requires proof that the judge abandoned impartiality and that the appellant was prejudiced as a result. This is the same standard the presiding judge applied when reviewing Laura's motion for change of judge for cause on appeal. This is so much less fun knowing that Gingras retired from like his troll job thing that he was doing.
He turned his Twitter back on.
Yeah, but he's like we got to troll him a little bit, I think. You know what? We got to drag him out of the weeds. We got to get him back posting.
I can wait till Vlad. right? Because I don't have anything prepared.
Well, on appeal, Laura did not argue actual prejudice. The record is replete with evidence supporting the trial judge's ruling, and Laura invited scrutiny regarding her alleged visit to Planned Parenthood by changing the location and date in her testimony multiple times. The Court of Appeals conducted a brief prejudice analysis, even though Laura did not properly develop those arguments on appeal. Upon finding waiver, the reviewing court could have just rejected the arguments without further discussion. Instead, the record, at every stage, there you go, at every stage of the proceedings shows extraordinary patience and fairness to Laura, despite persistent unreasonableness. The trial judge kept control of a difficult case, and the reviewing judges found no prejudice from one insignificant misstatement of trial testimony. When the record so thoroughly supports the trial court's conclusion and justice has been done, reversal would serve no meaningful purpose. Indeed, this is like his Shakespearean moment. Indeed, there comes a time when every case must end. Otherwise, the process becomes more important than the resolution.
Am I baked? What is going on here?
That is
It's time
dope.
for this
I like
case to
that.
end.
I mean, yeah,
That's
but
amazing.
I don't know. That feels like one of those thoughts that I would write down in my notes app when I smoke a bunch of, like, oh god.
By the way, Clayton's requesting an award of attorney fees and costs incurred in response to the petition for review pursuant to ARS 25324 and 809G. And is that the end?
Yeah, it is.
All right. That's a good
I
place to
thought
go.
that was never going to end. You kept going.
Look at
on
it this
and
way,
on.
Lauren. You're sitting in your chair, right?
Better than sitting in Omar's chair, I guess.
You're
chair
enjoying
is
sitting in
awesome.
your chair. Would you rather just sit in your chair, or do you want to talk about your chair?
I could probably do both if you get me the right time.
I mean, yeah. But anyway, what he's saying is being able to sit in the chair is more important than just talking about a chair.
Totally. Wait, who's saying that?
Marcus,
Oh, Mark.
in his complete obliteration of Laura and David S. Gingras Esquire's
It would have been way
horrible
more
appeal
Such a mess.
to the Arizona Supreme Court.
it would have been
Right.
way more badass if his entire response was, there comes a time when every case must end. Otherwise, the process becomes more important than the resolution.
Well, they should
Mic
have just
drop.
put a link to that Rickroll video and been done with it.
All right. Is that the end of this analysis? Is there anything to analyze?
No, I think I'm good here.
I think that, yeah.
I think the
think
only
you
thing this
pretty thoroughly-
document is missing is a picture of somebody punching out Conor McGregor. That's about it.
Well, Omar's got that in his thumbnails, so we're fine.
I do?
Yeah, you
I
got
have-
Exactly.
you got
Yeah.
a sticker here, bro.
Oh, Mariatani case.
Whoa!
With $5. Thank you so much, young lady. I very much appreciate that. I do have a thumbnail that I once made of David Gingras with balls in his face.
That's probably what I'm thinking of.
Shaq was dunking on him.
My
And then it was that.
brain just blocked out the balls. I mean, Jesus Christ.
Well, folks, that's all I have for you in terms of analysis on this
All right.
appeal. I've taken it
Amazing.
about as far as I can take it, man. There's literally nothing more. There's nothing of merit to argue against for Gingras's attempt, and I think he knows it. He knows it, man.
Who are
And
you having
so-
in your? Who are you having on Flad?
Well, not Bruce, apparently. Schnitzel will be there. Brad will be there. We may
Sorry.
have a couple of others. We'll see.
What are you going to talk about?
Well, that's always a wild card, but generally, it's going to be lots of family law shenanigans, probably cases of infidelity, probably weird sex questions. There's probably going to be questions about relationships and should I do this and should I do that. It's going to be a smorgasbord of shenanigans. And so you're always advised when entering the Flad to come well lubricated with your alcohol of choice and dial in, because that's the official start of the weekend is when we do Family Law After Dark.
I'm not.
Oh
doing
yeah, Bruce is
no
well
alcohol
started.
For me. I'm just gonna go get super baked and I'll probably watch. We'll see.
Totally. Hey, if you wanted to pop in and troll, just let me know.
I will, but I'm not gonna tell you when. It's just gonna happen.
I'll
So,
send you a link anyway.
Yeah. I mean, I already got it. I think it's your reusable one, right?
No, I changed it.
That feels personal. You have to send it to me again then.
I'll send it to you
Wow.
again.
Yeah. Okay. Well, I'm just gonna come in there and just like take everything off the rails the way that you just did to me. We're just gonna keep doing that until the end of time. I guess is trading that back and forth. That
Yeah.
responsibility. So.
No, it's the same flat link, Lauren.
Oh, I feel like you're lying to me a lot today.
No, just
The new same one or the old same one?
it's the one that you've always used.
No. Okay. Now I'm just confused.
I think it's the new one.
No, it is the old one.
I'll give you 20 minutes of my mess, and then I'll just watch the rest of it.
All right.
There you go.
Right.
I have a Google Doc with both.
All right, folks. I love y'all. I'll see you in about a half hour.
All right, man. See you later. I was just gonna let you sit there and do that and not push the button by everyone.